done that needs to be done?
From the state, yes.
What about the defense?
I would say, Your Honor, this is not letting any cat out of the bag or secret. We will be filing self-defense. I know we have 30 days prior to trial, according to Criminal Rule 12.2. I'm about halfway through the motion, abiding by specificity that I must comply with the state. My understanding of that ruling is I have to give the witnesses and the addresses and the names of those individuals. That's the part I'm finishing up on the motion right now. So beyond the defendant, we have no physical evidence, but we would be, I think some of those witnesses would be under cross-examination. They're also disclosed on the state's list. So we have no hidden witness that we're bringing out beyond the defendant and some of the state's witnesses, Your Honor.
Okay. And how many witnesses are you predicting you'll call? I know it's a little early to say for sure. I mean, are we going to be able to do this in 2 days?
Mm-hmm. Yes.
You agree with that? Yes. Right. Because I know we have stuff scheduled on the 13th.
We might have, we might still be deliberating on Wednesday morning, maybe.
Yeah, okay, well, we can deal with that. Okay. Anything else that needs to be discussed?
Not from the state.
Not from the defense.
All right, thank you. You're remanded back to custody, Mr. Morris.
Yes, I'm right now.
Okay, this is case number 23 CR 146, State of Ohio versus Isaac Garrison. Present on behalf of the state's prosecuting attorney Collins. Present on behalf of the defendant's attorney Jacob Wagner. And are you Isaac Garrison?
Sir.
All right. Mr. Garrison has been charged in a 2-count indictment of aggravated trafficking. Excuse me. Aggravated trafficking and aggravated possession of a fentanyl-related compound, first-degree felony. The matter was set for a status on Monday and had to be continued because I was in trial. And I have been presented today, Mr. Garrison, with a plea of guilty form which says you're going to plead guilty to count 1. This is a 4-page document. At the bottom of page 3, the last sentence reads, I enter this plea voluntarily. Below that appears to be signature Isaac Garrison. Did you sign this plea agreement that I'm looking at?
Yes, sir.
When did you sign it?
Set today.
Okay. Now, when you signed this agreement, did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing.
Yes, sir.
And is this something that you and your attorney had been talking about before he came here today?
Yes, sir.
And did he go over this with you and explain everything to you before he signed it?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
Do you feel that you were rushed or pressured in any way into signing this agreement?
No.
Did you sign it voluntarily?
Yes.
Are you going forward this afternoon voluntarily?
Yes.
Right, the agreement states you're going to plead guilty to count 1, aggravated trafficking in a fentanyl-related compound, a first-degree felony. It further states that You understand that the penalty for that could be 3 to 11 years, and a fine of $20,000, a mandatory fine of $10,000, and a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
Now, with regard to the prison term, 3 to 11 years is a minimum sentence that is set by the judge, and it is mandatory. And that means it has to be served. It cannot be reduced. No early release. The only thing is any jail time credit you would have would count toward that. You understand that?
Yes, sir.
Now, also under the law, for this type of offense, once you complete the mandatory term that's imposed by the court, the Department of Rehabilitation and Corrections could decide that they should extend your term by up to 50% of whatever sentence was imposed by the judge. And that's an analysis that they make. The court doesn't have anything to do with that. And so what that means is that any sentence that's imposed by the court, you have to serve, and then it could be extended by additional 1/2. So if the minimum term of 3 years was imposed, it could be an additional 1.5 years, which is half of 3. If a maximum of 11 years was imposed, it could be extended by an additional 5.5 years, which is half of that number. So that means that the potential sentence in this case could range from 3 years as a minimum mandatory up to 11 years as minimum mandatory, with maximum being an additional 1/2 of whatever number between 3 and 11 the court picks as a maximum. You understand that?
Yes, sir.
You facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, parole, community control, post-release control, or probation for a felony?
No.
All right, now you also need to know that under the law, if you are convicted and sentenced to prison, and of course you will have to be sentenced to prison if you're convicted, upon completion of the sentence imposed by the court and any extension that might be made by the DRC, it is mandatory that you be placed on post-release control supervision for a period of at least 2 years, up to a maximum of 5 years. And the adult parole authority will set those conditions, and a parole officer will be supervising you. If during that period of time they determine that you have not complied with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for any single violation of those conditions. There is a cap or maximum of half of whatever prison term was imposed for all violations, but if you commit a new felony while under post-release control supervision, then in addition to whatever sentence a judge in the new case can impose, that judge should also sentence you for committing that offense while under post-release control supervision to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now the charge in this case, in count 1, alleges that on or about July 6, 2023 in this county, Scott Allen Clay and you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, Schedule II controlled substance, in an amount that was equal to or exceeding 20 grams, but less than 50 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offender or another person, in violation of Section 2925.03A2. So that's the charge that I've just read to you with the penalties that I've just described. Now, Mr. Garrison, do you understand what it is you've been accused of having done in that count of the indictment, what they say you did, when, where, and how they allege you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No.
He takes prescription meds, Your Honor.
Okay. What prescription medications are you taking?
Good, when we talk to court, stand up.
I'd say a PTSD med, a sleeping med, and a ADHD med.
Now, do any of those medications interfere with your ability, you can sit back now, interfere with your ability to understand what's going on here this afternoon, or
No.
accurately communicating your thoughts?
No.
All right. Now, has anyone threatened you to make you plead guilty here today?
No.
Now, on page 3, there are several lines printed in bold and underlined, which read as follows. Defendant shall enter plea of guilty to count 1. State will dismiss count 2. State and defense jointly recommend 4 years incarceration, mandatory incarceration. Looks like the original, well, there was something different in there. It's been whited out and 4 has been written in by ink. And that was agreeable with the state.
Yes, Your Honor.
And then it goes on to say, defendant agrees to cooperate fully in the prosecution of the co-defendant, cooperate fully with the state and task force, including testimony if necessary. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty?
No.
Now, under the law, Mr. Garrison, the matter of sentence is up to the judge, not to the parties. And so, even though there's a recommendation by both parties that you receive 4 years, which is a mandatory sentence, and could be extended up to 6 years, that's not binding upon the court. If you plead guilty, once I've heard all the information, I could decide that's not the correct sentence. It could sentence you to as little as 3 years or as much as 11 years, mandatory. You understand that?
Yes, sir.
All right, now you hold any license or certification from any state governmental agency that regulates any occupation or profession?
What's your driver's license?
What's that?
A driver's license? No.
All right, now you have certain constitutional rights you must understand before I can accept a plea from you today. You do have a right to have counsel. Mr. Wagner was appointed to represent you since you did not have the funds to hire your own counsel. Now, he was not appointed simply to try to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide you do not want to do this, that you want to defend against the charge, he'll continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Garrison, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They would be instructed on the law, and then that jury would determine by unanimous verdict, meaning all 12 of them would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing your right to have a jury trial. In that case, you would have what's called a quarter bench trial, which means that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them in open court through your attorney. What that means is that the witnesses against you are required to come into court, testify in public, in front of you and your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you are presumed innocent of this, you have a constitutional right not to testify. What that means is that no one can make you testify. The prosecutor can't, the judge can, it's up to you. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in this proceeding at any time by anyone. In fact, no one's even allowed to comment about that except in one situation. If you should have a jury trial, then the judge would instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you are presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of the offense. What that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused by being indicted. In fact, under the law, you're not required to present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt or prove beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed a crime, and it exercised or invoked all the rights that I've just described for you today. Now, if you should change your plea from not guilty to guilty, that is the opposite of the not guilty plea. A guilty plea would admit the allegations in count 1, admit that they're a crime and that you committed that crime. And that plea would waive and give up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. So with that exception, a plea of guilty waives, gives up the right to a jury or a court trial. It waives, gives up the right to confront witnesses against you in open court and to cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, the state's not required to prove you're guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. And I'm not sure, but it also, if I said it or not, but just to make sure I did, it also waives, gives up the right to confront witnesses in open court and have your attorney cross-examine. Plea of guilty subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence or under the certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties for count 1?
No, sir.
You understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes.
And you understand all the constitutional rights I've explained?
Yes, sir.
All right, if you need to speak with Mr. Wagner about anything before we go any further? All right, then is it your decision to withdraw your not guilty plea and plead guilty to count 1 pursuant to the terms of the plea agreement we've just gone over?
Yes, sir.
Then as to the charge which alleges that on or about July 6, 2023 in Highland County, Ohio, Scott Allen Clay and you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, a Schedule II controlled substance in an amount equal to or exceeding 20 grams, but less than 50 grams when you knew or had reasonable cause to believe the controlled substance was intended for sale and resale by the offender or another person in violation of Section 2925.03A2, charge of aggravated trafficking in a fentanyl-related compound, carrying a mandatory minimum sentence of 3 years up to 11 years as imposed by the court, and an additional potential for an additional 50% being added onto that by the DRC, a fine of $20,000, a mandatory fine of $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. Court finds on this date, open court defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendant is found guilty of the offense. Count 2 is dismissed. All right, since this is a mandatory sentence, there's no discretion. The court will go ahead and proceed with sentencing. Anything from the state?
Only what's contained within the plea agreement, Your Honor. We would note that, again, this is a case involving fentanyl, so we would ask the court to take that into consideration. That is why we asked for the 4-year mandatory term. This is Mr. Garrison's first, definitely his first felony conviction. He may have had a few, yeah, he actually has no prior criminal history at all, so he's young, but he went for an awfully big charge right out of the gate. He was cooperative after he realized that we knew way more than he thought we knew. He did cooperate with the state, and we do appreciate that. And we also appreciate handling the case in a timely fashion. That being said, this is fentanyl, and it's a lot of fentanyl, so we would ask the court to follow the joint recommendation.
Mr. Wagner?
Your Honor, again, we asked the court to follow the recommendation. Ms. Collins kind of echoed what I was going to say, or she spoke what I was going to say. Sadly enough, he is a young man, and he's supported here by family. He's got a daughter. I don't know if he did go to rehab for a while, and I'm not busting my client out. People often run to rehab to try to avoid prison, but he did check himself in. He was doing well. He was calling me weekly. And I agree with Ms. Collins. He had no criminal record. He just picked a drug and a weight that kind of took the case out of my hands. Once apprehended, he went through Miranda with the investigating officer, gave a full confession. I'm not belittling his conduct, but even in dealing with this drug, he wasn't even very good at that. He didn't sit there and lawyer up and say, I'm not talking. I wish we had more discretion, but we don't. Or I wish I had wiggle room here, but I don't. It's not a triable case. The court's stuck on the record of the sentencing. Again, I just hope he can take this time, do well with it in prison. He's been in my office. We've met, talked with his parents. It's just a horrible situation where a young man made a horrible mistake. I don't think he's out there selling to all the people in the Greenfield area, but he had a lot of weight. I think he was a user that got wrapped up in buying too much and put himself in a situation way over his head. That's all, sir.
All right, Mr. Garrison, anything you would like to say?
No.
Well, it's unfortunate that you're here for the first time on a case that's mandatory incarceration, and that's because fentanyl is so deadly. It sounds like you've had, some of your own issues, but you can't resort to, assisting or participating in the distribution of a controlled substance, particularly in amounts like this. That's why the law looks at it so seriously and requires a mandatory sentence. That being said, the recommendation is for 4 years, 1 year above the minimum, in view of your lack of a prior record and your cooperation, the court thinks that that's the appropriate sentence. So it is the judgment order of the court that you be and are hereby sentenced to a mandatory minimum sentence of 4 years to the Department of Corrections, Rehabilitation Corrections, and that sentence could be extended at the discretion of the Department of Rehabilitation Corrections to 6 years, depending upon their analysis of your situation in prison. It is also the law that upon completion of this sentence, you will be required to be put under post-release control supervision by the Adult Parole Authority for at least 2 years and up to 5 years, which means you'll be supervised by a parole officer under the terms they set. And if during that period of time they determine that you have not complied with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for a single violation. But there is a cap or limit, in this case, of half of the prison term, or 2 years, for all violations. However, if you committed a felony under post-release control, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment grant and execution's order. According to the sheriff, you have 7 days of jail time credit, and you'll be given credit for that amount against your sentence. Now, has there been any change in financial circumstances since I appointed Mr. Wagner to represent you?
No.
All right, then the court will find that you do not have the financial means to pay the mandatory fine, and it's not likely that you would have in the near future, so that fine will be waived. There'll be no license suspension imposed, nor any fine. There's already a rule of the fine. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody, Mr. Garrison. All right, are you Carl Walter Lockhart?
Yes.
All right, this is case number 23 CR 170. State of Ohio versus Carl Walter Lockhart. Present for the state is, well, first of all, this hearing is being conducted by Zoom, and he is appearing from the jail. His attorney is Jacob Wagner, appearing by Zoom. Also representing the state, appearing by Zoom, is Assistant Prosecutor King. This matter is set for a status hearing. It was continued, I think, for Monday because of a trial docket. Mr. Wagner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
We are, sir.
And you're all right with that, Mr. Lockhart?
Yes.
All right, since you're not going to be sitting in the courtroom next to him, if you have any questions at any time, you just tell me, and I can put the two of you in the breakout room where the two of you will be the only ones on the screen, and no one else can be able to see you or hear you, and the deputy will step out of the room during the period that you're talking to your attorney, okay?
Okay.
All right, now, the defendant is charged along with 6 other defendants in a number of charges. It's like he's indicted in count 1, which is a second-degree felony. Count 14 and 15. Count 31 and 32. 36 and 37. Now, I've been presented with a plea form, Mr. Lockhart, which indicates you're going to plead guilty. I'm going to hold the first page of that up to the camera that has your name, case number, and plea of guilty and the charges. You recognize that document?
Yes.
And on page 4, at the very top of the page, there's a sentence that reads, "I enter this plea voluntarily," and immediately below that appears to be the signature, Carl W. Lockhart. I'm going to hold that up to the camera and ask you, is that your signature there?
Yes.
And when did you sign this, Mr. Lockhart?
Last week, Your Honor.
Last week? Okay.
Yes, sir.
All right. Mr. Lockhart, when you signed this agreement, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes.
And did you have enough time to fully consider the matter before you made that decision and signed the document?
Yes.
Did you sign this agreement voluntarily?
Yes.
And did your attorney explain everything to you before you signed it?
Yes.
Now, it's been a few days since that happened. Is this still what you want to do?
Yes.
All right. Now, the agreement states on page 1 that you're going to plead guilty to counts 1, 32, and 36. Count 1 is engaging in a pattern of corrupt activity under 2923.32A1 of the Ohio Revised Code, a second-degree felony. Count 32 is a forfeiture specification. Count 36 is a trafficking and heroin charge alleging under 2925.03A2, also a second-degree felony. Now, it further states that you understand that the possible prison term for counts 1 and 36 is a minimum of 2 years, up to 8 years, imposed by the judge. And on count 36, the same thing, 2 years to 8 years. The difference is count 36 is a mandatory sentence that has to be served, whatever number the court picks. On count 1, it's not mandatory. It's presumed, but it's not mandatory. Now, also, so that means that you could receive a sentence of anywhere from 2 years up to 16 years if they were ordered to be served consecutively. And the sentence on 36 would be served first because it's mandatory. And under the law, the Department of Rehabilitation and Corrections could extend the sentence on either count, but only one, not both, for a period of up to 1/2 of whatever prison term was imposed. So, if you received a sentence of 2 years to 2 years on each count, then that means that it can be extended by 1/2 of one of those sentences. 1/2 of 2 is 1, so that means that sentence on that charge could be extended by up to 3 years. If there was a maximum sentence of 8 years, then it could be extended on that charge up to 12 years, because 4 and 8, 4 is half of 8, you add that to 8, and that's 12. So that means that your sentence could be anywhere from 2 years as a minimum mandatory, up to a total of 16 years, 8 of that mandatory and 8 of it not, that's being served consecutively. And with the additional 4 years that could be added on either of those 2 counts at the discretion of DRC, it could mean a maximum sentence of 20 years. You understand that? And on count 1, there's a possible fine of up to $15,000. On count 36, there's a possible fine of $15,000. A mandatory sentence fine of $7,500, and a license suspension of 6 months to 5 years. You understand that? Now, with regard to the forfeiture specification in count 32, that would simply, there's not a fine or a jail sentence possible. That simply results, if admitted or convicted, in loss of the property to the government, which in this case looks like $75 and a 2004 Chevy truck. You understand that? Right now, Mr. Lockhart, as I mentioned, you must serve a prison term on count 36 of at least 2 years, and up to 8 years is selected by the court. And then it could be extended by up to half of the prison term. Now, regardless of whether the sentences are to be served consecutively or not, on completion of your prison term, it is mandatory that you be placed under post-release control supervision by the Adult Parole Authority for a period of at least 18 months, up to a maximum of 3 years. So that means you'll be supervised by a parole officer, a term set by the Adult Parole Authority, and if during that period of time they determine that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to half of whatever prison term the judge imposed for all violations. But if you commit a new felony, then in addition, whatever sentence can be imposed by the judge in that new case, that judge could also sentence you for committing that violation while under post-release control to an additional period of a year, whatever time is left on the period of post-release control, whichever is greater. And if that happened, that could be served consecutively the sentence of the new case. You understand that? Now, I forgot to ask you earlier, are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Okay. All right, now, the charge in count 1 of the indictment reads that on or about the period of, get that here, November 1, 2022, continuing through May 1, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, you, Evan Scott Clay, Charles David Howland, April Lynn Koch, and other unindicted co-conspirators did recklessly while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity, and at least one of those incidents was a felony of the 4th or 5th degree, violation of section 2923.32A1. So that's the charge of engaging in a pattern of corrupt activity with the penalty that I just described for you. Now, count 32 alleges that on or about it just says that the property, following property was used in the course of or intended to be used in the course of the violation of section 2923.32A1, or the property was used in, intended for use in, derived from, and directly or indirectly realized through conduct in violation of ORC 2923.32A1, and any interest of Carl Walt or Lockhart is subject to forfeiture pursuant to ORC 2923.32B, and that lists item 1 is $75 U.S. currency, and item 2, 2004 Chevy pickup truck. All right, and then count 36 alleges that on or about March 10, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, Charles David Howland and you, did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute heroin, Schedule 1 controlled substance, an amount equal to or exceeding 10 grams but less than 50 grams, when you knew or had reasonable cause to believe the controlled substance was intended for sale or resale by the offender or another person in violation of section 2925.03A2. That's also the second-degree felony, the same penalty as described earlier, count 1, except that any sentence imposed by the judge is mandatory under the law and cannot be reduced in any way, other than by jail time credit. Now, Mr. Lockhart, do you understand what it is you've been charged in those 3 counts in the indictment, what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed those charges with your attorney, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise at trial, the possible outcomes of the trial with Mr. Wagner?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Now, has anyone threatened you to make you plead guilty here today?
No.
Now, under the third page of the agreement has a number of lines that are printed in bold and underlined, which I will read at this time. Defendant shall under plead guilty to count 1, count 32, count 36. State will dismiss remaining counts. State and defense jointly recommend 4 years of incarceration on count 1, consecutive to 4 years mandatory incarceration on count 36. Defendant agrees to cooperate fully with the task force and cooperate fully against all co-defendants. Defendant agrees to repay by money to the task force in the amount of $140 joint and several with April and Cope, and you agree to the forfeiture outlined in count 32. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty?
No.
Under the law, the matter of sentence is up to the judge, not the parties. So even though there's a recommendation you receive a total of 8 years, 4 of which would be mandatory, that's not binding on the court. If you plead guilty, once I've heard all the information, I may decide that's not the correct sentence and it should be as little as 3 or as much as 11 on either of those 2 counts. I'm sorry, 8 years as either of those 2 counts, or a total of 16 years, which would add the possibility of an additional 4 years from DRC for a total of 20 years. You understand that? All right, now, Mr. Lockhart, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I don't quite understand that.
Well, it'd be something like if you worked as a pharmacy technician or a vet tech or a nurse or a barber or something like that.
No.
Okay. Now, you have certain constitutional rights, Mr. Lockhart, you must understand. First, you have a right to have counsel. Mr. Wagner was appointed to represent you in this matter since you didn't have the funds to hire your own attorney. Now, his appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide that you do not want to plead guilty, that you would rather defend against the charge or charges, all of the other, these and the others, then he will continue to represent you, including going to trial and defending you at trial if that is what you would like. Do you understand that?
Yes, sir.
Right? Now, under the law, you have the right to have a jury trial in these matters in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence would be presented and they'd be instructed on the law. And then that jury of 12 people would have to decide by unanimous verdict, meaning all 12 would have to agree as to a verdict on each of the counts as to whether or not the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial, and then in that case you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, Mr. Lockhart, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that? Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come into court to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes.
Right now, under the Constitution, Mr. Lockhart, you're presumed innocent. I'm sorry, you have a privilege against self-incrimination in this matter, which means that you cannot be forced to give evidence in this case at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't, you decide. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, with one exception. If there is a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each of these three offenses. So what that means is the burden of proof isn't on you to try to prove you're not guilty on these charges simply because you've been indicted. In fact, under the law, you're not required to put on any defense at trial on your own behalf. You may, but you're not required to. But whether you present any defense any defense at all at trial, the burden of proof will still be on the state of Ohio to prove your guilt of proof beyond a reasonable doubt on every essential element of each of these three charges, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Now, originally you were indicted and you entered a plea of not guilty. And that plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty on these three charges, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, and that you committed that crime. And that plea would waive or give up all the rights that I've described for you today, except the right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine through your attorney in open court, waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. Would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you'd be saying you're guilty and that's what you'd find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove your guilt. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I should sentence you to the maximum sentence, run under certain limited circumstances to file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that? And are you a U.S. citizen, Mr. Lockhart?
Yes.
All right, now, do you have any questions about any of the charges or the penalties for those charges?
No, sir.
You understand?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
And you understand the sentencing recommendation is not mandatory, not binding on the judge? All right. Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
You have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes.
Well, first of all, do you have any questions?
No, I mean, you've been extremely long, so my attorney has.
Okay. So is there anything else you need to discuss with him before we go any further?
No.
All right. Then is it your decision, Mr. Lockhart, to withdraw your not guilty plea, plead guilty to count 1, 32, and 36 pursuant to the plea agreement that I've just gone over?
Yes.
All right. Then as to count 1, which alleges that on or about the period of November 1, 2022, continuing through May 1, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, that you, Evan Scott Clay, Charles David Howland, and April Lynn Koch and other co-conspirators unindicted did recklessly while being employed by or associated with directly or indirectly conduct or participate in the affairs of an enterprise through a pattern of corrupt activity. In at least one of the incidents of corrupt activity is a felony in the 4th or 5th degree, violation of section 2923.32A1 of the Ohio Vice Code, a second-degree felony carrying a possible prison term between 2 and 8 years set by the judge, with the possibility to be extended by up to 1/2 by the DRC, a fine of $15,000. How do you plead? All right, and count 32, which alleges that that the following property was used in the course of or intended to be used in the course of a violation of section 2923.32A1, where the property was used in, intended for use, derived from, directly or indirectly, or realized through conduct in violation of our ORC 2923.32A1, and in interest of Carl Walter Lockhart is subject to forfeiture pursuant to ORC 2923.32B, to wit, $75 in U.S. currency and a 2004 Chevrolet truck with a VIN number listed therein in the indictment. How do you plead? And then as to count 36, that alleges that on or about March 10, 2023 in Huntington County, Ohio, and as a continuing course of conduct in Fayette County, Ohio, Charles David Hallen and you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute heroin, a Schedule I controlled substance amount equal to or exceeding 10 grams or less than 50 grams, when you knew or had reasonable cause to believe it was intended for sale or resale by the offender or another person in violation of section 2925.03A2, which is a second-degree felony with a possible prison term of 2 to 8 years as a minimum set by the judge, which would be mandatory, and a possibility of extension by up to 1/2 by the DRC, fine of $15, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead? All right, the court finds on this day at open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendant's found guilty of counts 1, 32, and 36. The remaining counts are dismissed as to this defendant. All right, since there is a mandatory sentence here, there doesn't seem to be any reason to defer sentencing or order pre-sentence investigation, so the court will go ahead and proceed with sentencing forthwith. Anything from the state?
Thank you, Your Honor. The state would ask that the court follow both recommendations and sentence the defendant to 4 years on each count consecutive. This would be the same sentence the co-defendant Charles Howland received. The forfeiture of property in count 32 would be to the Highland County Task Force. Would also ask that the clerk of courts be ordered to issue a title for the forfeited vehicle to the county commissioners. And finally, the restitution in this case of $140 to the task force, joint and several with the April Code. That's all, Your Honor. Thank you.
All right, Mr. Wagner.
Your Honor, we would ask the court to follow the recommendation. This is the case when I met with Carl. Everyone's involved on the resolution. Admitted his culpability from the very beginning. And it's consistent with the other co-defendant, Your Honor.
Okay, Mr. Lockhart, anything you'd like to say?
No, sir.
All right, then it's a judgment of the court that you be and are hereby sentenced count 1 to a minimum term of 4 years, and as to count 36, you are sentenced to a mandatory minimum term of 4 years. And those two sentences are run consecutively to each other for a total of 8 years. Now, as I indicated to you, the DRC could increase that 4-year sentence on one of those two charges to up to 6 years, which is 2 would be half of 4. So you add that on to 4, that's 6. So that means that your sentence would be 8 years as a minimum, up to 10 years as a maximum. With regard to count 32, it's ordered that pursuant to the plea agreement and the admission, the cash is forfeited to the task force, as well as the proceeds from the truck, which is to be forfeited to the name of the county commissioners, and the clerk will be directed to issue a title to the county commissioners pursuant to this order. Now, Mr. Lockhart, I assume there's been no change in your financial circumstances since I appointed Mr. Wagner to represent you? Then the court will find that with regard to count 36, you do not have the means to pay the mandatory fine, nor is it likely that you will in the future. Now, I'll also inform you that because of the conviction, once you complete the prison term, in this case, then the Adult Parole Authority could put you under, must put you under post-release control supervision for at least 18 months, up to a maximum of 3 years. You'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to half of the prison term imposed by the judge, which is 4 years for all violations. However, if you committed a felony, then in addition, whatever sentence the judge in the new case imposes, that judge is also authorized to sentence you for committing that violation while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in a new case. You're also granted 50 days of jail time credit. According to this, you were arrested on September the 12th, is that correct?
Yes, I think it was 11.
Okay, you were indicted on, pardon me?
Yeah, I'm sorry, it could be the 12th.
You were indicted on the 12th. You were served with an indictment? All right. The indictment was on the 12th, and according to the records, you were taken into jail on the 12th. So that's a total of, let me make sure that's correct in terms of the total here.
Your Honor, probably what happened is he was arrested and spent one night in the Greenfield jail before he was brought over here.
Okay. So was he arrested before he was indicted?
Yes, he was, Your Honor.
All right, so it'd be an additional day. All right, well, the sheriff's records are off. This was dated the 3rd of November. I didn't notice it. They're not off, they're right, except that it was run on the 3rd. So today is the 9th. And so they have a total of 50 days, plus 1 would be 51. And then the additional time from November 3rd to today would be 5 additional days. So, oh, wait a minute, let me look here. 18 in September, 31 in October is 49, and 9 is 58. Okay, 58 days of credit, plus 59 total, plus 1 for the Greenfield. All right. Now, you're also ordered to pay the court costs, Mr. Lockhart, and if you do not pay those, the clerk can collect that through various means, including levying on your bank accounts, wages, and other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could order you to do community service in this county and give you credit for each hour you work, and an hourly rate set by the court each hour you work will reduce your judgment by that amount till paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody, Mr. Lockhart. Thank you.
Mine's pinging, I thought I was going to get in
Yeah.
trouble.
All right. Are you Elizabeth Margaret West? All right, this is case number 23 CR 213, State of Ohio versus Elizabeth Margaret West. This is a bond review hearing. Ms. West was read yesterday, and pursuant to the statute, it's required that the court conduct a review within 48 hours, or 2 business days, I should say. And so we're conducting it here today because tomorrow's a holiday. Mr. Wagner, Jacob Wagner, is appearing on her behalf. And this hearing is being conducted by Zoom. He's appearing on his phone and representing the state's prosecutor, Assistant Prosecutor King. Defendant was indicted on 3 counts of trafficking and fentanyl-related compound and 3 counts of possession of fentanyl-related compounds. Bond was set to an amount of $5,000 plus an OR. Mr. Wagner?
Yes, sir, Your Honor. I am very limited on my client's background. I will get out as serious as I can. I would just simply ask the court if they would consider, Your Honor, reducing this to an OR bond probation department says. But again, Your Honor, I will update or supplement the motion if I feel a bond reduction is necessary.
All right, Mr. King?
Thank you, Your Honor. It's the state's position that given the nature of the pending charges, the current bond is appropriate. So the state would just ask that the current bond remain in place. That's all. Thank you.
Well, according to the court network, Ohio Court Network report that we generated, Ms. West did have a warrant issued for her in July of 2021 out of Washington Courthouse, Municipal Court, I believe, for failure to appear at that time. I see there were related misdemeanor charges at that time, and looks like some of those were from Highland County, but there was also a charge in the courthouse in 2004. She doesn't have any prior felony record, but given the fact that yesterday I think it was very clear that she was having withdrawal problems, and given the failure to appear history, I'm concerned that she's not in a state that she's going to be able to appear until that issue is addressed. So if there's a further request for that, I'll consider it, Mr. Wagner, but this time bond will remain the same. All right.
Yes, sir.
All right, she'll be remanded back to custody, Ms. West. Thank you. Case number 23-CR-141, State of Ohio versus Scott Allen Clay. Present for the state, Prosecuting Attorney Collins. Present on behalf of the defendant is Attorney William Armentrout. Are you Scott Allen Clay?
Yes, sir.
May I approach?
You may. Thank you. All right, defendant is charged along with the co-defendant Isaac Garrison in a three-count indictment. One count of aggravated trafficking, one count of aggravated possession of a fentanyl-related compound. Both of those are first-degree felonies. And then one count of aggravated possession of a fentanyl-related compound, a fifth-degree felony. This was set for a status conference, I believe, or maybe a Monday, and it was continued until today. And I've been presented, Mr. Clay, with a plea of guilty form, which indicates you're going to withdraw your not guilty plea guilty to count one of this indictment. This document looks like it's 4 pages, and down at the bottom of page 3, the last sentence reads, "I enter this plea voluntarily," and then immediately below that appears to be signature Scott Clay. Did you sign this plea agreement that I have here before me?
Yes, sir.
When did you sign it?
Monday,
Monday?
or no, last Thursday.
Might have been last Thursday.
Last Thursday.
Last Thursday? Okay. Now, before you signed it, did you go over this with your attorney and have him explain everything to you and answer any questions?
Yes, sir.
And did you understand when you signed it that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing?
Yes, sir.
Do you think you had enough time to fully consider the matter before making this decision?
Yes, sir.
Need to speak up.
Yes, sir.
Okay. Now, it's been a few days since then. Have you had any second thoughts, or is this what you still want to do?
That's still what I want to do.
All right. So you're entering into this agreement to plead guilty voluntarily.
Yes, sir.
Now, the agreement states on page 1 that you are going to plead guilty to the aggravated trafficking and a fentanyl-related compound in count 1 under 2925.03A2 of the Ohio Revised Code. Further, it states that you understand the maximum penalty for that could be a sentence of between 3 and 11 years as set by the judge, and that is a mandatory sentence. It cannot be reduced by anything other than any jail time credits you would have prior to being delivered to the institution to serve your sentence. Now, the law also provides that it's possible that the Department of Rehabilitation and Corrections could decide based on their analysis of your situation while you're in prison, that your sentence should be extended by up to half of whatever sentence the court imposes. So, if the minimum sentence was imposed of 3 years, DRC, Department of Rehabilitation Corrections, could extend that to up to 1.5 years more, or which would be a total of 4.5 years. If the maximum sentence was imposed of 11 years, they could extend it by up to 5.5 years, which is half of 11. So that means that your minimum sentence possible in this case, which is required by law, there's no change in it, the court can't do anything about it, would be 3 years, and the maximum could be 16.5 years based upon 11-year sentence as a minimum by the judge, mandatory, an additional 5.5 by the DRC. You understand that?
Yes, sir.
It's also a mandatory fine of $10,000. The maximum total fine is $20,000. There's a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Are you currently facing any felony charges anywhere else?
No, sir.
Are you on probation, community control, parole, or post-release control from any jurisdiction?
No, sir.
All right. Now, under the law, if you're convicted, you will serve a prison term, and once you complete that prison term, it is required by law that you be put under post-release control supervision under terms set by the Adult Parole Authority for a period of at least 2 years as a minimum, up to a maximum of 5 years. So you'll be supervised by a parole officer. If during that period of time the Adult Parole Authority or APA decides that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, but there is a cap or limit of half of your prison term for all violations. But if you should commit a new felony while under post-release control, then in addition to whatever sentence a judge in a new case could impose, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, the charge in this case, count 1, reads that on or about July 6, 2023 in Hyneken County, Ohio, you and Isaac Garrison did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute a fentanyl-related compound, a Schedule II controlled substance, an amount equal to or exceeding 20 grams, or less than 50 grams, when you knew or had reasonable cause to believe it was intended for sale or resale by the offender or another person in violation of Section 2925.03A2 of the Ohio Revised Code. So that's the charge with the penalties I've just described. Now, Mr. Clay, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
On page 3, there are several sentences that are printed and in bold that I will read as follows. Defendant shall enter a plea of guilty to count 1. State will dismiss the remaining counts. State and defense jointly recommend 4 years mandatory incarceration. Defendant agrees to cooperate fully in the prosecution of the co-defendant, cooperate fully with the state task force, including testimony if necessary. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, Mr. Clay, the matter of sentence is up to the judge, not the party. So even though there's a recommendation that you should receive a sentence of 4 years mandatory, that's not binding on the judge. So if you plead guilty, once I've heard all the information that's presented, I could decide that the sentence should be something different. Could be 3 years or it could be up to 11 years. With the additional 50% of whatever that sentence is being added by DRC as a potential. You understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
You have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have counsel. Mr. Armentrout was appointed to represent you since you didn't have the funds to hire your own attorney. His appointment wasn't simply to get the case worked out, but to make, or provide, I should say, any defense that may be available to you under the law that you would like him to provide. So if you decide you do not want to do this, that you want to defend against this charge, He'll continue to represent you, including a trial, defending you a trial if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge would instruct them on the law. And then that jury would decide by unanimous verdict whether the state proved your guilt by proof beyond reasonable doubt. Now, if you didn't want to have a jury trial, and a unanimous verdict means that all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing your right to have a jury trial. In that case, you would have to call it a court or bench trial. And that means instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else who may be present. After the prosecutor's done asking questions, your attorney would ask questions. And that's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, you request the court issues a court order, that's a subpoena, and that would force those witnesses to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution, Mr. Clay, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, originally you entered a plea not guilty, Mr. Clay. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised and revoked all the rights I've just described. If you change your plea from not guilty to guilty, that is the opposite of a not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime. And that plea waives, gives up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, the plea of guilty waives or gives up your right to a jury or a court trial. Waives, gives up your right to confront witnesses against you and to cross-examine through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination because you say you're guilty, then that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you the maximum sentence, or under certain circumstances you can file an appeal, any appeal that you would file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And I don't remember if I asked you, but are you a U.S. citizen?
Yeah.
Okay. All right. Now, do you have any questions about the plea, about the charge of the possible penalty?
No, sir.
You understand it?
Yeah.
Any questions about the plea agreement?
No.
You understand it?
Yeah.
And you understand the recommendation on sentencing is not binding on the court?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yeah.
Do you understand those? Okay. Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Now, is there anything you need to speak with your attorney about before we go any further?
Wait for I'll take care of that. Say no, sir.
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to count 1, pursuant to the terms of the agreement we just went over?
Yes, sir.
Then as to the charge which alleges that on or about July 6, 2023 in Highland County, Ohio, you and Isaac Garrison did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute a fentanyl-related compound, a Schedule 1 controlled substance in an amount equal to or exceeding 20 grams or less than 50 grams when you knew or had reasonable cause to believe The controlled substance was intended for sale or resale by the offender or another person in violation of section 2925.03A2, charge of aggravated trafficking in a fentanyl-related compound, a first-degree felony, carrying a possible, a mandatory sentence of anywhere from 3 to 11 years as set by the judge, with whatever sentence imposed being extended by up to 1/2 by the DRC, a fine of $20,000, a mandatory fine of $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, court finds on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, prove the same, pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of the offense. Charged in count 1, counts 2 and 3 are dismissed.
May we approach, Your Honor?
You may.
This is.
All right, sentencing will be set for December the 5th at
Almost a month.
1:30 p.m. Your bond will be continued. Make sure you report to the probation department today or whenever you're supposed to. And they're going to get an assignment notice from bail. Now, again, I explained to you that the manner of sentencing is recommendation not binding on the court. So if you don't show up, or you do something else and get yourself in some trouble, you may look at more time. So you need to make sure you comply with the court's order. All right?
Yes, sir.
All right. Thank you.